Mm, There, and we are live now.
Awesome. All right. So, as we mentioned before, thank you all for joining us. My name is Adriana, and we are joined here by my colleague Nipa, who is going to be handling tech for us today, and our wonderful presenter, Sam Himmelstein. And he is a retired partner with Himmelstein, Gribben, and Joseph LLP. We are going to be going through how to break a residential lease within New York City. All right, so just a few things for our training today. Any questions he is going to be answering throughout the presentation, as well as I'm sure we'll have time at the end for questions as well. So if there's any questions, please refrain from trying to unmute your mic. Go ahead and type those questions right in the chat, and we will make sure that he's able to see them and answer those questions. We are going to get started. Sam, once you're ready, take it away.
Hi, everyone. So some of you, I understand we have a crowd of some tenants, some organizers, some lawyers. So some of you may know me and some of you may not. So just a brief introduction. I am a retired partner at Himmelstein, Gribben, and Joseph. Um, I worked in legal services for 4 years, and 40 years ago, I joined and founded this firm. And so I was in private practice for most of my career, representing exclusively tenants. Our firm never, ever represented a landlord, never would evict anybody. Um, so over the course of my career, I had many, many hundreds of, if not thousands of tenants who had problems with lease breach issues. But one of the hallmarks of any ethical law firm and lawyer is you don't want to take a case where you can't provide your client with cost-effective representation. So we didn't litigate or represent too many of these people if they were in court, because we would often have to charge them more than was in dispute in the case. So what became critical was counseling people if they got to us before they broke their leases on what to do and how to make their situation have the best outcome. One of my partners, when I was talking to him about this recently, said, I would just tell people to leave because the odds that the landlord would sue them over a relatively small amount of rent is unlikely. And in general, that's true. Most landlords, if a tenant breaches their lease, and let's just create a hypothetical, they have 6 months left on the lease. They let the landlord know. The landlord starts looking for a replacement tenant. Let's say finds one in 2 months. They apply the security deposit to one of the missing months. No landlord is going to sue a tenant over 1 or 2 months of rent. So you don't see that many of these cases litigated. And when we did this training a few years ago, my recollection is that it was in the midst of COVID. And during COVID, you may recall, uh, everyone was breaking their lease because people didn't have money. People were unemployed. People's businesses were failing. So during that period, and the landlords couldn't do anything about it because the courts were shut down. So during that period, you had many, many, many people breaking their leases. It's not as prevalent now because apartments are so scarce. When people get an apartment these days, they generally try to hold on to it. So, but people still find themselves in situations where they have to break their lease. It could be that they're experiencing economic difficulties and they can't pay the rent. It could be that they've been relocated and they have to move to another state. Maybe they're getting married and they're moving in with their spouse. There's a whole bunch of situations that occur where people in the middle of a lease have to leave. So that's what we're going to explore today. So where we start, and we can go along. There's an outline that you'll see in the middle of the page. I'm going to pretty much follow that for the entire session. So you can read along there, and you'll be able to access that when we're finished. So my first point there: negotiate, negotiate, negotiate. I can't tell you how important that is. A lot of people think that lawyers' job is, when you ask someone, what's your main job as a lawyer? They say, well, to win the case. No, that's not actually the truth. The truth is to get the best possible outcome for your client, given the circumstances. And a settlement, if your client can live with the outcome, is almost always better than a court case because of the cost, because when you go to court, you don't have control over the outcome. So what I wrote here is you have to reach out to the landlord. You have to say to them, look, I have to break my lease. Here's why. There are some landlords who will act decently in these situations, believe it or not. And there are arrangements that you can propose to the landlord to resolve it. And I suggest some of them here. Say to the landlord, look, if you let me out of the lease, let's say you have a year left on your lease and your rent is $3,000 a month. Say to the landlord, look, I'll let you keep the security and a month's rent if you let me out of the lease. And many landlords, will appreciate the fact that you've reached out to them, that you're being honest. But then again, there are some basic rules of negotiation, and some of them are listed here. Negotiate slowly and deliberately. Don't put your final offer on the table at the beginning of the negotiations. Very important. I find that when people negotiate on their own behalf, there's a level of anxiety. I experience this myself when I'm negotiating on my own behalf as opposed to when I'm representing somebody. And you want to get the thing over. You want it resolved. So a lot of people will say, okay, here's what I'm willing to settle for. And they make an offer. And what happens? The landlord comes back with a counter offer. And if you've made your best offer right out of the box, you have nowhere to go. So what you have to try to do is make an initial offer that is, that gives you some wiggle room. Try not to seem anxious. Don't bargain against yourself. And if you can, retain an attorney. Even though I didn't represent a lot of tenants in court in these cases, I did represent many, many people in negotiations in these situations. So if you reach a settlement, it's very important that it has to be memorialized in a formal agreement called a lease termination and release, or a lease surrender agreement. It's really, really important to do that, not to just rely on a handshake or an exchange of emails, but to have a document which specifically references the lease and indicates what the terms of your leaving are. The next point, if you scroll down, is B. There it is. Give as much advance notice to the landlord as possible. Allow them to show the apartment. Now, when we first did this, as I mentioned, when we first had this training, it was in the middle of COVID. And you see that sentence there, it may be difficult for the landlord or you to find a replacement tenant or to rent the apartment at the same rent that you're paying. That was true during COVID. It's less true now. As many of you probably know, we have a housing shortage. And when an apartment becomes available, there are usually people lined up to rent it. So if you can find somebody who's willing to take the apartment, great. If they fit the landlord's, financial parameters, if they make 30 or 40 times the rent, if you can present somebody, that's great. Communicate in writing when when you're negotiating. Not all of it. There's got to be a certain amount of it where you're actually talking either on the phone or face to face. But it's good to send confirming emails during the negotiation to make sure that you have a record. Very often, the landlord will, if you claim that the reason that you are breaching the lease is because of financial hardship, the landlord will very often ask you to prove it. And that, believe it or not, is not an unreasonable request on the part of the landlord.
Um,
So be prepared
Sam,
to do that. Yes.
sorry, I don't know if you want to answer it later, but there was a question that says, what if the tenant's apartment is rat infested and the tenant wants to leave but wants their security deposit back? And I
We're going to
think,
get to that.
yeah.
We're definitely going to get to that. So hold your question until later. Okay. Keep communications between you and the landlord. Very important. If you're in a building with, 10, 20, 50, 100 apartments, landlords don't want word to get out that they're letting people out of their leases. And so if you blab around the building what's going on, it's going to make it less likely that you'll have a deal. So keep everything between you and the landlord. If you're in a market apartment, meaning an apartment that has been deregulated, it's always good to check your rent history at the Division of Housing and Community Renewal, which is very easy to do these days. You can do it online, you can visit them, you can do it by mail. Because almost every apartment at some point was stabilized. And as we know, during the period of deregulation, many, many apartments were illegally deregulated. So if you look at the rent history, and again, it may involve bringing it to a lawyer, there may be something fishy in that rent history, which could cause the apartment to be re-regulated. So if your landlord is being difficult or stubborn and you find out that you have even an argument that the apartment really should be rent stabilized and that the rent might be lower, that can be a really powerful weapon for you. So that pretty much sums up most of the, the 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 initial stages of it. In other words, you have to break your lease and you have to approach the landlord. These points are, the point I wanted to make about that. But then what happens is very often the landlord won't negotiate, or having negotiated, they won't make a deal with you. Well, New York has a nice law called Real Property Law, Section 226B. It was passed many, many years ago, I think in the early 80s, and it's called the Right to Sublet Law. And it has two sections. The first section says that a tenant can assign their lease to another person. And the difference between an assignment and a sublet is that when you assign the lease, you're actually giving it over to somebody else. That person becomes the tenant. You are released from any further obligations under that lease, and everybody can walk away. The way the statute is worded is that if you propose to assign the lease, and of course, assigning the lease means you have to find someone who is actually willing to take over your lease, called an assignee. So you have to dig up someone again who will likely be qualified for the apartment given the rent and their employment situation. And you have to then propose that to the landlord in writing. When it comes to an assignment, the law says that if the landlord unreasonably refuses consent, then there is no assignment, but you are released from the lease. Now, people will often say, what's an unreasonable refusal? And I can tell you that I went to law school for 3 years. I practiced law for 44 years, and I still don't know what reasonable means. You know, we there's the reasonable man in law, or the reasonable woman, and so much has been written about this. So what it really comes down to is that if you present somebody to the landlord who is financially qualified, meaning they can afford the rent, they don't have a bad history, they're not a convicted felon, Donald Trump is not your assignee, and the person would normally be qualified, and they turn that person down, or they turn them down for discriminatory reasons, illegal discriminatory reasons, then that's an unreasonable refusal, and then you can walk away. If the landlord reasonably refuses your assignment request, then you're not released from the lease and the lease continues. The other option is to sublet the apartment. Now, subletting, the procedure for subletting is even more complicated. So you have to come up with a subtenant. Again, they have to be someone who's qualified. And there is a procedure that's actually written out step by step in the sublet law that tells you exactly how to do it. And I believe attached at the end of the materials, there's also a pamphlet that I and several others authored several years ago, which was included a chapter on how to sublet your apartment. And the procedures in that, even though it was written sometime in the 80s or 90s, are still valid as to how to go about it. And it's complicated and it's technical. There are certain documents that you have to attach. You have to draw up a sublease or a proposed sublease. You have to send the request a certain number of days before the sublease starts. You have to be very, very careful to follow the procedures exactly the way the statute lays out. And subletting works a little differently than assignment. If the landlord unreasonably refuses consent and you believe that the landlord's refusal, or you believe that the landlord should have consented, the law says you can go ahead with the subletting anyway. And then the problem is the landlord may bring you to court on what's called an illegal sublet eviction proceeding. So whether you really want to go that road is not clear. But that's your remedy. If you feel that the landlord has unreasonably refused consent, you just go ahead with the subletting and take your chances. The landlord's threat to litigate if they don't like that is often a bluff. A lot of landlords will wait a little while and see if the subtenant can pay the rent, and if they do, they'll move on. The next section talks about the roommate law. You probably all know that New York also, in addition to having this great sublet law, has something called the roommate law. Now, the roommate law works like this. If there's one tenant on the lease, you're entitled to have one additional roommate. And if there's more than one tenant on the lease, you can't have additional roommates, but you can replace tenants with roommates if one of the tenants leaves. So if there are 3 people on the lease and one of the persons has to leave and thereby is technically breaching the lease, you are allowed, without the landlord's consent, to get a roommate to replace that person. And in the case of multiple tenants, that is probably the best option. If you can find a roommate, again, and again, in terms of their financial qualifications, you as the co-tenant probably want to make sure that they're financially qualified. But the landlord has no veto power over your roommates, even if the landlord feels that you don't even have to give them, the landlord, their finances. The only requirement on the roommate law is that you have to notify the landlord within 30 days after the roommate moves in. And I can tell you, in reality, very few people even bother to do this. Okay. The next section. These are kind of general considerations. Again, and this is me being practical and not legal. Consider having the assignee or the subtenant pay less than the amount that you're paying for the balance of the lease. You're paying $3,000. Ask them if they'll pay $2,750 and make up the difference. Why? It's better than litigating. It's better than ending up in court. You end up having to go out of pocket, but you end up possibly in a better situation than you would in court. Keep in mind that if you're a stabilized tenant, you cannot sublet the apartment unless you have an intention to return to it at the end of the sublease. So subleasing for a stabilized tenant who is leaving permanently, who's breaching the lease and leaving permanently, is not an option because they cannot honestly say that they intend to return to the apartment at the end of the sublease. And also subleasing cannot, stabilized tenants can only sublease for 2 years out of any 4. And of course, they cannot charge the subtenant more than what they're paying in rent. If they do that, they can be hit up for triple damages on the overcharge. Okay, so none of this works. The landlord still is not willing to make a deal, is not listening to you. You can't make an agreement. Well, then you can simply, the first step is to surrender possession of the apartment. And you should do that as quickly as possible. And I gave you a sample letter here to the landlord as to what you would include in that letter. Now, it's very important, common mistake that people make. You know, a lot of people say, I don't bother to read my lease. It's all the same. It's all legal gobbledygook. Why should I read it? It's boilerplate. Well, when it comes to sending a letter like this, every lease has in it a provision called notices. And it says any notice to the landlord must be sent, and then it says certified mail, regular mail, whatever. Make sure you follow that. Send the notice the way the lease requires, and then do overkill. Also send it by some sort of overnight. Also email it. There's nothing to stop you from doing additional notices, but you at least have to comply with the notice provision that's in the lease. And it's important to say what I've said in that sample letter. There are some key phrases there. The tenant has permanently vacated the apartment, effective immediately, meaning you have informed the landlord that you're gone forever. The apartment is vacant, and that has to be true. No one, you can't leave anybody behind, and you can't leave anybody who's claiming possession of the apartment. Remove all of your personal possessions and let the landlord know that it's broom clean and that they can re-rent the apartment. Very important, take photos of every inch of the apartment before you leave. And I would say I would add to that, take videos to show that you are leaving the apartment in good condition. So surrendering possession does not constitute a termination or a surrender of the lease. That can only happen by agreement, because since a lease is a contract, and you need both parties to agree in order to terminate a contract. However, I guess as part of the Housing Tenant Protection Act of 2019, New York finally came out of the dark ages. Well, a little background. In contract law, there is a concept called mitigation of damages. And give you an example. If I have a contract with you to buy some goods and you don't deliver, I have an obligation to try to get those goods from someone else, even if it costs more. And then if I want to sue for breach of contract, I sue for the difference between what I would have paid you and what I would have paid and what I had to pay the other person. That's called mitigation of damages. New York, until 2019, held that the mitigation of damages concept didn't apply to leases. And it was insane. New York was one of the few states in the country that followed that rule. Well, everything changed in 2019, and that was a massive change, and it was extremely beneficial. So what does that mean? As soon as you send that surrender letter, it triggers the landlord's obligation to mitigate, which is defined, and I have the exact language in the outline. The landlord has to use reasonable and customary actions to rent the premises at fair market rent or the rate agreed to during the term of the tenancy, whichever is lower. So what that means is that as soon as you leave, the landlord has to do what they would normally do to re-rent the apartment. And they have to market it at what you were paying. If they can get more, they can try, but they have to market it at what you were paying. If they end up unable to rent it at what you were paying, which these days is not common, then you could be liable for the balance of the lease for the difference between what they re-rented for and what you were paying. Now, how do you know whether the landlord has complied with the mitigation law? Well, when you rented the apartment, you may have gone through a broker. You may have gone onto Street Easy. The landlord probably has certain procedures in place for renting apartments, which generally you can check. Excuse me. So, go to those websites and see if your apartment is being rented. And I refer in the outline to using other investigative techniques to monitor whether the landlord is in compliance. So let me be a little careful here. People often say about lawyers, when I say to people it's illegal for lawyers to lie, a lot of people look at me and said, what are you talking about? I thought lawyers lied for a living. Well, believe it or not, it is illegal for us to lie or make a misrepresentation or to advise other people to. So when I say using standard investigative techniques, what I'm referring to, and I guess I have to be careful here, I'm not suggesting you do this, but private investigators do this all the time. You pose as a prospective tenant, or you have a friend appear to be a prospective tenant, and see whether or not the landlord is actually renting the apartment. The mitigation is really key, and once that law was passed, it really, really cut down on the number of cases that landlords brought against tenants. Okay, so everything else fails, and now you're sued. Well, those lawsuits will be brought, depending on the amount in controversy, in either Supreme Court, civil court, or small claims court. Most of them are brought in civil court, which has jurisdiction of cases. I actually think it's now perhaps $10,000 to $50,000 instead of 25. I think that might have changed. So most of these are brought in civil court, and what happens is if you're sued, you'll get something called a summons and a complaint. It's for those of you who've been to landlord-tenant court, it's very, very different than landlord-tenant court. You have 20 or 30 days to answer the summons and complaint. And then you're looking at a lawsuit that could potentially take 2 to 3 years to resolve. And it is good to have a lawyer in those cases, but for the reasons that I stated at the beginning, it's often not cost effective to hire a lawyer. If you're being sued, let's make up a number, for $20,000. When I represent somebody in civil court, if I'm going to do it right and go through all the procedures, go through what is called pretrial discovery. I don't know if you all know what that is, but in most lawsuits, each side has the right to demand documents from the other side in support of their claim, to take depositions of the landlord and other witnesses. By the time you get through with that, you're looking at legal fees which will exceed the amount you're being sued for. So again, it's not really practical, and I'm not going to kid you, it is also not easy to represent yourself in a case in civil court. But unfortunately, it ends up being the reality. Now, most of these cases are like collection cases. When you get a collection notice from an agency, it says you're justly indebted, and if you don't pay this or dispute the debt, we're going to sue you. They're similar. They're just You're just being sued for a relatively small amount of money. The overwhelming majority of those cases get settled, and very few of them actually go all the way to trial. But some of them do. But most of them settle at something in between what you're being sued for and what you'd be willing to pay. So again, don't panic if you get sued. You should at least consult a lawyer if you can. But it's not the end of the world. I'm going to skip over collection letters. Oops, I just messed up accidentally. What did I do here? Okay. One sec.
Are you still able to see the screen?
Now I am. Okay.
Perfect.
Okay. So this is a little technical and lawyer-like, but just to give you an example of the defenses that you might have if you're sued in housing court. I'm sorry, in civil court or Supreme Court. You can challenge service of the summons and complaint if you feel you were served improperly. That doesn't get you very far. It's called a dismissal without prejudice, which means the landlord can refile the case. Failure to mitigate, we discussed that. If you believe that the landlord did not comply with their obligation to mitigate damages and didn't make those reasonable and customary efforts to re-rent the apartment, that's a defense and should lead to the case being dismissed. Breach of warranty of habitability. This goes to the question that the woman asked earlier about the rats. If while you were living in the apartment, there were repair problems, service problems, heat, hot water, leaks, peeling plaster, falling paint, vermin, you might be entitled to a reduction in your rent under what is called the warranty of habitability, which is a wonderful statute in New York that says that every apartment in New York City has to be habitable, and it's the landlord's responsibility to make sure that it is. And you can interpose that as a defense. So let's say you're sued for 3 or 4 months rent. You can assert warranty of habitability as a defense to that. And if the problems went back quite a long way before you vacated, you can assert it as a counterclaim where you say, not only should the amount that I'm being sued for be reduced and should I be given an abatement, but I'm entitled to an abatement for the period when I actually paid the rent, and I'm entitled to get some of that back. There are defenses that are related to the warranty of habitability that I didn't include in the outline. So if you are, there's a defense called constructive eviction. Constructive eviction occurs when the apartment conditions are so bad that the apartment becomes unlivable, and in effect, you're evicted from it. Now, the only way you can assert that is if you abandon the apartment. You can't claim that you were constructively evicted from the apartment if you're still living there, unless you're claiming partial constructive eviction. So that would occur, let's say, if you have a two-bedroom apartment and one of the bedrooms is unlivable because it has terrible leaks and mold. Then you have what's called a partial constructive eviction. So if the conditions were that bad and you had to abandon either all or part of the apartment, that can be a defense in addition to the warranty of habitability. Illegal deregulation, we talked about that before. If the landlord sues you and claims that you are not, or were not, a stabilized tenant, and you think you have an argument that perhaps the apartment was not properly deregulated, you can assert that as a defense. You can claim that you were overcharged while you were there, and you're entitled to recover that overcharge, interest, and triple damages. And I can tell you that if the landlord sees that defense and feels that they have any vulnerability, they're very likely to drop the case very quickly, because they are not going to want a judge to rule that that apartment is still rent stabilized. If you have a lawyer, just about every lease in New York City has a clause in it that says that if you are sued by your landlord and the landlord wins, you have to pay their legal fees. And that's an enforceable clause. New York passed a law many years ago which says if that clause is in the lease, if there's a clause which says that you have to pay the landlord's legal fees, if you win the case, they have to pay your legal fees. The reality is, in the vast majority of cases, everybody absorbs their own fees if you have a lawyer, but it's a powerful weapon. And if a landlord thinks that he might not only lose the case, but he might end up having to pay the tenant's legal fees, nothing sticks in their throat worse than that. They hate paying tenants' legal fees. So that's also a powerful weapon. That pretty much wraps up what I have to say. I'm happy to answer questions. There are some materials below, some of the statutes that I cited. There are links for them. And there is that subletting guide, which I hope when you go there shows up. That's a how to assign and sublet your apartment if you're going to go that route. So
Awesome.
I'm
So
ready for questions.
do you want us to go through and read each question?
Yeah, please. That would be great.
Perfect. Nipa, you want to do it or you want me to do it?
Up to you. If I can do it, since you're screen sharing.
Okay, go ahead.
Um, so is part of a security deposit forfeited for breaking the lease?
Security deposit can be used for unpaid rent. The reality is that landlords will not return your security if you break the lease, right? And, since security is now limited to 1 month's rent, it's probably not worth fighting over. What's important, though, is to remember that New York, in 2019, as part of the changes in the law, New York also revised the security deposit law. And I don't have it cited here, but if you look it up, there are some very strict procedures now about how and when a security deposit has to be returned. And I probably should have included in this some materials, but I didn't. One of the things you can do when you are about to leave is request a joint inspection of the apartment. That's in the security deposit law, and the landlord has to comply with that. And then they have to give you a written list of any items that they claim might constitute a basis to withhold your security. So it's good to look at that and maybe, force the landlord to comply with those procedures, because it might give you a basis to recover the security deposit. But the reality is you're not going to get it back if you breach the lease. It's going to take, if you breach the lease, it's almost definitely going to take at least a month for the landlord to re-rent the apartment. They have to clean it up. They may have to do a couple of repairs. They have to market it. They may have to paint it. And during that, it's a legitimate basis to withhold the security for that 1 month, I would say. The landlord has a legitimate claim to do that.
Um, and I and just to clarify, they have to return it within 14 days or they waive it, correct?
Correct.
Okay.
Correct.
Um, do all these provisions for assigning a lease apply to unregulated units?
Yes.
Okay.
They apply to all residential apartments in New York. There may be an exception for owner-occupied apartments with less than a certain number of units, but yeah, they apply to all apartments. They don't apply to co-ops and condos, and they don't apply to any apartments that are government regulated. So you can't sublet or assign a Mitchell-Lama apartment. You can't do it with a NYCHA apartment. If you're getting Section 8, you can't sublet or assign anything where there are qualifications for having the apartment. You can't sublet or assign. But if it's a purely private residential apartment, yes, it applies to all apartments.
If there is no deposit, can a lease be broken?
If there's no security deposit, is that what they're asking? No, a lease is still a contract. If you sign a lease, it's a contract that says the landlord is giving you this apartment for a year or 2 years, whatever the period is. You can occupy it exclusively during that period. The landlord can't, come in and take it away from you. It sets forth what the rent is. And that's a binding contract. And if you walk away from it before it ends, you're breaching it. So yeah, it's not dependent on whether you have a security deposit or not.
If there's a judgment against you from housing court and you left the unit, can you raise the warranty of habitability?
Yes. The warranty of habitability is one of those statutes. It's got some great language in it that says essentially that a tenant can't waive their rights under the warranty of habitability, even if they sign an agreement, you know, even if the lease says so. And the fact that you may have a judgment against you, well, unless in that judgment, in other words, if you went to housing court and you litigated and you brought up the warranty of habitability as a defense, and that defense was somehow adjudicated or resolved in that case, then you can't bring it up again. But if the judgment against you did not in any way involve the warranty of habitability, then you can bring it up again.
Do you have to attempt to assign the lease before you can permanently vacate and have the landlord mitigate by finding their own replacement?
Okay, you don't have to attempt to assign. You can just walk away and take your chances. It's not legal, right? I mean, you're breaking the lease. You could be sued, but there's no requirement that you attempt to assign. It makes sense to try to come up with a replacement tenant for the reasons that among the reasons that the questioner listed. When you present the landlord with a viable replacement, it's very, very difficult for the landlord to then say, I complied with my obligation to mitigate when they were presented with an alternative by the tenant. Imagine how that would look in court. So if you can present, again, you have to screen people. You have to ask them about their background. You have to find out, if they've ever been to housing court, if they have, they might have a record there, if they, what their employment situation is. But if you think that they would qualify, yes, it makes the most sense to present somebody who's willing to take over the lease.
Say you have a colorable claim for illegal deregulation on a rent stabilized apartment. How can that be brought offensively for a tenant?
Um, Assuming that you're still in possession of the apartment or assuming that you've left? Can the questioner answer that question or both?
Um,
If you're
let's
still
see,
here,
both. They said
both.
both.
Okay. So it's a little bit beyond the scope of this, but I'm happy to talk about it. If you are in an apartment and you get your rent history and you look at it or you bring it to a lawyer who looks at it and says, I think you have an argument that your apartment was illegally destabilized, you have a bunch of options. You can sue the landlord in state Supreme Court, claiming that your apartment is stabilized and suing for overcharges, interest, triple damages, and attorney's fees. You can file a complaint at the DHCR claiming for rent overcharge. And in that overcharge case, claim that the apartment, even though the ostensibly not stabilized, really is. Or you can withhold your rent, or if the lease expires, hold over, provoke the landlord into bringing a case against you in housing court, and then assert as a defense and as a counterclaim to the court case in housing court your claim of stabilization status and rent overcharge. Each of those forums has advantages and disadvantages. I'm happy to summarize them. It'll take me a couple of minutes. So personally, I avoid the DHCR like the plague when it comes to these cases. They're inconsistent. They take forever. I had one case, believe it or not, that went on for 14 years at the DHCR. But sometimes they don't even look at the file for a year or two after you've sent your complaint in. So I tell people to stay away from it. On the other hand, if you don't have a lawyer, it is probably the easiest of the three to navigate. Supreme Court. In my firm, we like Supreme Court, among other reasons, is that you have a right, you have what is called as of right pretrial discovery. Now, again, we mentioned that before. Pretrial discovery occurs in most lawsuits. Any of you who've been involved in any kind of a lawsuit, a personal injury case, a contract case, knows what discovery is. Both sides have to produce all the relevant documents that support their claim and submit. The parties and sometimes witnesses have to submit to depositions. And when I say it's discovery as of right, that's contrasted to housing court, where if you want pretrial discovery, you have to ask the court or the other side has to consent. In Supreme Court, it's a matter of course. And in these cases, what we do is we take the deposition and get the documents, not only of the landlord, but of the construction companies and contractors. Very often the rent increases are based on what we call individual apartment improvements, where the landlord did certain renovations in the apartment and claimed to pass on a percentage of those, which varied from 1/40th to 1/60th. And that's how they arrive at the new rent. And so what we do in these cases is we take the deposition of the contractors and we ask for all of the documents that they used relating to that. Going to housing court is the third option. The reason I like housing court is that very often in Supreme Court, when you go in front of a judge with a case involving landlord-tenant, the judge will look at you and says, you know, Mr. Himmelstein, this is why I left housing court, to get away from cases like this. They really don't like landlord-tenant cases for some reason. I think it's because a lot of them don't understand it. But in housing court, you don't have that problem. The judges actually seem to like these cases because they're not run-of-the-mill, just about getting the rent from social services. They involve some meaty issues. The problem is that they don't have that discovery as of right. And again, assuming you have a lawyer, you would have to make a motion for pretrial discovery. Having said that, they are almost always granted in these types of cases. The judges almost always grant pretrial discovery in cases where you're defending a claim based on illegal deregulation. But they might limit it. They might order you to finish within a certain amount of time. They might limit who you can depose. They might chop down your document request. But so again, it's either housing or Supreme, and each has their advantage and disadvantages. In either event, these are not easy cases to do without a lawyer. They're complicated, and some people can do it, but it's not easy.
How much of a security deposit may a landlord keep due to wear and tear in an apartment?
That's a good question. Well, again, if you look at the statute, you have a right to request an inspection within, a certain number of when you notify the landlord that you're leaving. If it's ordinary wear and tear, they're not allowed to deduct anything. The only thing that they're allowed to deduct from a security are conditions that were caused by the tenant that go beyond ordinary wear and tear. So, plaster falling off the wall, a leak, damage from a leak, mold, all that is the landlord's responsibility, and the landlord cannot use that. On the other hand, if you were moving a piece of furniture and you poke a hole in the wall, it's your responsibility.
What about a move-out letter due to rent arrears versus court?
Not sure I understand the question.
Yeah, if you want to clarify the question down below, and then we can come back to it.
I mean, if you're, I can try this. If you're in arrears and the landlord hasn't sued you yet in housing court, one advantage to getting out is that once you surrender possession, and again, writing the letter as close as possible to what I included in the outline, the landlord can't take you to landlord-tenant court anymore. Landlord-tenant court only has jurisdiction over cases where tenants are in possession of the apartment. So once you are out of the apartment, the landlord's options are to sue you in civil or Supreme Court, where you will get full discovery, and it'll take years for them to get a judgment against you, etc. So if that answers the question, great. If the person wants to clarify, I'm happy to expand.
Is there any way to break a lease due to domestic violence without being penalized?
Ooh. All right, you got me. I believe that there is a statute in New York that allows you to break a lease in the event of domestic violence, but I don't have it handy. If anyone here or on the chat would like to Google that and give us the answer, but I believe I've never dealt with that law, so that's why I'm not that familiar with it. But I believe that there is a statute that deals with that in New York State.
So, do you know, like, just to follow up, if both the victim and the perpetrator are on the lease, is there any part of the law that
Oh, no,
allows
no.
them to?
I think it's only for the victim being the tenant.
Okay.
Right. I don't think that if a tenant commits domestic violence, that does not give them a basis to get out of the lease. It's only, I believe, if they're the victim of it. So
Well, would it allow like the tenant to remove the perpetrator from the lease?
again, I don't think so. I think it just gives them the basis to get out of the lease, but we'd have to look at the law. So if anyone can can Google, um, you know, come up with a good Google question. Can I break my lease if I'm the victim of domestic violence? We might get the answer in New York. We might get the answer very quickly.
Can a landlord move the security deposit to a bank branch that is outside of New York State?
No,
Can the
has to be in
land,
New York. Has to be in New York. It has to be in an interest-bearing account. But as we all know, and the statute says at it has to earn interest at the same rate as a savings account, less 1%. Now we all know that banks don't give interest on savings accounts anymore, right? If they do, it's 1%. So if you have a security deposit, the interest is effectively zero. But it has to be held in a New York bank, and they have to tell you where it is.
can the landlord demand the most recent W-9 form when it already has one?
No, no, unless, well, they might, if the lease is being renewed, they might be able. No, well, the W-9 is because of the security deposit, right? And once they have it, no, they can't ask for it again. No. Yeah, I would say no. I think I saw in the chat that someone came up with the domestic violence law. I think they said real property law 227C. So if somebody wants to look that up and we can see what it says.
Um, I can post the link and I don't know if you want to screen share it, Adriana.
Yeah, someone in the chat added the link. We can click on it and see what it brings up. Oh, it says that it's no longer available, but I can
Oh, if you want to use the link that I posted.
perfect. Let's see. It's in the chat, Nico.
Yeah.
Okay, I don't see it yet.
I can just send it to you.
Oh, got it, got it. Okay, there we go.
So that's B. We got it there. There we go. Termination of lease by there we go. Victims of domestic violence. If any lease or rental, agreement covering premises where a tenant or member of the tenant's household is a victim of domestic violence and reasonably fears remaining in the household because of potential further domestic violence, such tenant shall be permitted to terminate the lease and surrender possession pursuant to the provisions of this section and be released from any liability to the landlord subsequent to the date of termination. There you go.
So
So
they would still be responsible for background. So when they say subsequent to the date of termination, do they mean the date that they inform the landlord?
the date that they move out.
Mm.
Mm, okay.
Okay, good.
Um, I don't know if you can answer this question. Any legal advice for a client who has had their wages garnished due to unpaid rent years ago?
That's really a consumer credit issue, and but you know, if they if you have a judgment against you, the the judgment creditor is completely within their rights in garnishing your salary up to I think it's 10%, um, until they recover their debt. So I don't there's not much you can do with it. If the only way they can do that is if they have a judgment, right? It's not just be if the landlord says you owe it to me, they have to have a judgment, and then they take that to your employer and say, and with a notice of garnishment. And so I if I'm assuming this person has a judgment against them, and there's not much we can do.
So let's say in a scenario where they took them, like sometimes we'll have situations where they've already moved out, but the landlord still filed the case in court, and
In
because they
housing
moved
court,
in housing court.
and they
And
have made it clear that they moved. There's no question they moved out. They've given back the keys. They've surrendered possession. Then you can move to dismiss the case for lack of jurisdiction. Housing court really doesn't have jurisdiction where the tenant isn't in possession because, as the folks at housing court answers know, the enforcement mechanism in court, if you don't comply, is eviction. But you can't be evicted from a place that you're not in anymore. So most judges will, almost all will dismiss the cases if the tenant is gone.
but I think what happens a lot is that the tenant doesn't necessarily know that they got sued because they've moved and the papers were served at the apartment.
Ah,
And that's when the judgment comes in. Can they undo the
okay.
judgment?
Yes, yes. If you get a default, that's called a default judgment, right? So if you get a default judgment against you, in this case, you didn't know about it, um, and you suddenly find that that judgment is being forced, you can go to court, bring what is called an order to show cause, which is a motion filed with the court to vacate the judgment. And to prevail in that, you have to convince the court that you have a reasonable excuse for your default. In this case, it would be you never got the papers because you had left and the mail wasn't forwarded. And you have to convince the court that you have a defense to the underlying claim, meaning you're saying to the judge, it will be worth it for you to open this up because I can defeat this case. If you don't present both of those issues to the court, your motion to vacate will be denied.
Okay. So going into, I don't know if we're like going too far off topic, but if you move out, but let's say you leave like, I don't know, a couch or something that you never intend to take, and the landlord thinks they don't have possession because there's like that one couch left over, and they file the case, but you moved out. Where are they technically supposed to serve you if they don't really know where your new apartment is?
They have to make the reasonable efforts to try to figure out where you are. But if you haven't told them where you are, and it's not you're not listed in any public record at your new address, then the law allows them to serve at the last known residence. Um, so it's really, a lot of people think, oh, when I leave, I should hide. I shouldn't let the landlord know where I am. That's not really a smart thing to do. It's good. Have your mail forwarded because service of process is going to involve mailing. So make sure you leave a forwarding address with the post office if you don't want the landlord to know. Because regardless of what court you're in, all forms of service other than personal service involve follow-ups with mail, certified regular mail. So you'll know about the situation.
Okay. So landlords tend to do holdovers for not completing yearly forms for private tenants, but do not do the same for tenants with programs. Is this legal? They also threaten to evict.
Could you repeat the question? Sorry.
Landlords tend to do holdovers for not completing yearly forms for private tenants, but do not do the same for tenants with programs. Is this legal? They also threaten to evict.
It's probably legal. I mean, I've never dealt specifically with that issue, but it's probably legal because it's much harder to evict a tenant who's in one of those programs. They have additional protections that regular market tenants don't have. So I don't know what forms you're referring to. Tenants who are in programs like Section 8 or other subsidies, they have to, I believe, present yearly financial forms to the landlord, right? If you're if you're not in a program and you're in a market apartment, legally, I guess the landlord could, as a condition of renewing your lease, ask you to continue to prove that you know, that you're making enough money to have the apartment. You rarely see that. Most landlords, if you rent an apartment and you've paid the rent on time for a year, most landlords are convinced you're okay and will renew your lease without any documentation. But I don't think there's anything illegal about the situation that the questioner posed.
I think they may be referencing like J51 tax abatement apartments, because that's what we usually see, where they ask for like documents or like some other sort of tax abatement, and like in order to keep that up, they need to provide yearly income, even if it's not like it if their income isn't gonna change how much they pay rent.
I J, you're talking about rent stabilized J51 apartments?
Yeah, sometimes we've seen those like it's one of those tax abatement, and every year they have to like provide income documents, but it doesn't change how much their income, how much rent they'll pay, but
Hmm.
they still have to provide the documents.
I honestly don't know the answer. I'm sorry. Yeah.
So in the event that you live with someone and they get an order of protection against you, can you break the lease? I think we,
So you're the perpetrator of the domestic violence. No, you can't break the lease based on that. That would be kind of absurd, wouldn't it? Like to allow people to benefit from abusing somebody, right? It's the victim who gets to break the lease, not the perpetrator. No, if you were forced to leave an apartment or you chose to leave because of the situation like that, you'd still be responsible.
and then referencing the previous question, I think the person said that tenants are in a rent stabilized apartment.
They're in a stabilized apartment and they're being asked to provide this documentation. I mean, as far as I know, rent stabilized tenants, once you're in, the landlord cannot condition renewal of the lease on presenting any documents. There may be certain programs where that is required, but an ordinary rent stabilized tenant, there's really nothing that the landlord can ask as a condition of renewing the lease.
And somebody just mentioned that, well, this is Google, but I don't know if you can clarify. You must provide written notice to the landlord or if you are experiencing domestic violence in order to terminate your lease without being penalized.
I think when we were looking at the statute before, if you still have it, you can bring it up. We didn't get to it, but the next section, like after we read one section, and then the next section, I think said, see, procedure here. A tenant who meets the requirements, meaning they've been a victim of domestic violence, may terminate with a written notice to the landlord, any co-tenants. Notice shall specify the date, which is no, so they have to give at least 30 days notice. And it says how it can be delivered. So yes, there has to be notice. And it's all laid out there.
And I have a question going back to the question that was asked in terms of um like an order of protection situation. If it's a situation where someone has an order of protection against their co-tenant, whoever it may be, and that co-tenant is not in the apartment for a certain time frame, let's say 6 months. If the primary tenant that's in the apartment that's still there and they're the ones that filed the order of protection, let's say they're taken to housing court for owing rent, the tenant that has not been there for those 6 months, could they still be liable for that rent? They're on the lease, but they haven't been there due
Yes,
to order of protection.
yes. Just because you're physically absent doesn't relieve you of your obligation to pay rent.
Okay.
Leases, rent is what is called a joint and several obligation. So what that means is that if there are multiple tenants on the lease, each one of them is liable for the full amount of the rent.
Okay.
You can't go to court and say I only owe half because there are two tenants. The landlord could demand that you pay all of it, the other side pays, the other tenant pays all of it. So
Mm, I see. Even in the case of like, because we also do see a lot of roommate situations where, let's say a roommate or two completely abandon the apartment, and that tenant that's left is, the only one coming to housing court. Is it possible that they would be able to negotiate in any sort of way to only pay their portion and for the landlord to hold those other tenants accountable in another way?
well, I'm assuming that those other two roommates were also on the lease. Yes.
Right, right.
Okay. No, and I'm assuming that so there's one tenant left in possession. They're brought to housing court. No landlord is going to make an agreement saying, I'll let you stay and only pay your share of the rent while I pursue those other two people.
Mm.
They're never going to do that. They're going to say, you want to stay, you pay me the full rent, you go after the other two tenants.
Okay.
Yeah.
Okay.
And then also, when you are when your lease has expired and you haven't signed a renewal lease, you become a month-to-month tenant. And then you just want to leave. Is there a set amount of time that you have to give the landlord?
I'm not sure if it's statutorily required, but I always recommend 30 days notice. That
Okay.
seems to me to be a reasonable amount of time. There's a lot of statutes like the one we just looked at that has 30-day notice. The sublet law is 30 days notice. So, that seemed the the law always was, and I'm not sure if it changed, that the law requires landlords to give tenants 30-day notices. That's real property law, either 232A or C. There might have been an amendment at some point which also said that tenants had to give 30 days notice. But I always recommend it anyway. It just makes sense. So
And let's say your expired lease had said you need to give 60 days notice, but would that 60-day criteria now apply even
yes,
though it's
yes,
six?
the terms of unless there's a statute which specifically contradicts that says a tenant only has to give 30 days notice, the terms of an expired lease project into the monthly tenancy,
Okay.
other than the length of it, right? So once your lease expires, you pay rent for 1 month, that creates the month-to-month tenancy, and then the substantive terms of your lease continue to apply in that month-to-month tenancy.
Um, for rent stabilized tenants, is the surviving spouse of a tenant of record legally entitled to an updated lease with their name as the primary tenant? AKA, is a landlord legally obligated to provide a copy of a current lease with an updated tenant of record? Um,
Okay,
and
so we're talking here about succession rights. So the spouse of a deceased, the question was a deceased tenant, someone who died? Yeah.
yes.
The spouse of a deceased tenant is entitled to succeed to the apartment if they co-occupied the apartment with the tenant for 2 years immediately before the death, 1 year if the successor is over 62 or disabled, or when the relationship commenced, if it's shorter than 1 or 2 years, meaning if they got married 6 months ago, the succession period would be 6 months. And so if you meet those requirements, you as the spouse of the tenant can succeed, and the landlord has to give you a renewal lease in your name when the current lease expires. They don't have to add you or substitute you to an existing lease.
So I think where it becomes an issue for a lot of tenants is if they're trying to get like back rent assistance and they need a lease in their name. Is there anything that can be done then?
I don't think you can force a landlord to put someone on an existing lease. I've never heard of that. I don't think legally it would stand up. You're just gonna you have to try to explain to the people at the agency what's going on. But it sounds like what you said, people are having trouble. That's too bad. But it's the way I've always seen it work, and I believe that even if you look at the rent stabilization code, when it talks about succession right, it's all phrased in terms of renewal of leases, right? And that's when it occurs, and that's when the tenant gets added to the lease or substituted onto the lease.
And on top of that question, let's change the scenario. Let's say that let's say a husband and wife, right? We're both on the lease together. Husband passes away. But the management company is not for the renewal lease, giving the renewal lease just in the wife's name. Like it's continuing to come in the wife and the husband's name. Is there anything that pushes the management company to have that name removed and only have the surviving spouse on there, or not really?
Yeah. I mean, you should not. The landlord shouldn't want to have a dead person on a contract.
Right.
It's not smart, right? But if they are, um, they shouldn't be. And one thing the remaining tenant has to do is clearly document what has happened.
Okay.
Send the landlord the death certificate so that they can't deny it. And if they're still unhappy and landlord is not changing their mind, you can file a complaint at the DHCR for an improper lease renewal.
Okay.
And the DHCR, I believe, will then order the landlord to issue a lease only in the surviving spouse's name.
If you received a 14-day notice and have recently received renewal lease, can the tenant still proceed signing the renewal?
Yes. Non-payment of rent is not a basis, at least under rent stabilization, it's not a basis to refuse to renew a lease. And if they're a market tenant and they've gotten an offer of a renewal lease, the landlord could withdraw the offer at any time before it's accepted. So under basic contract law. So if that tenant wants to hold on to that apartment despite the arrears, they need to renew that lease as quickly as possible.
Okay. But I think I don't know if you can answer, but like with the good cause eviction law now, if they offer the lease and the tenant in an unregulated market is trying to negotiate for like a reduced amount, like they increased it like 500, they're trying to negotiate for 200. Can the landlord now bring them to court saying, hey, you didn't sign the lease, so now we want to?
If the increase was within the parameters of what the good cause eviction law allows, then the landlord can proceed to court. If the landlord has exceeded what the good cause eviction law allows, the answer is no. Remind me what it is, how much they're allowed to increase under the good cause law? 5%, is it?
It's like the CPI plus
Oh, yeah, that's right.
5%.
That's right. Yes, right. So, right.
So just a reminder that this training is about breaking leases, but I will ask this question. Um, I have a client who wants to take over her sister's unit. She has lived with her sister for 5 years. would that be a succession rights case? Her sister has moved out.
Ah, I'm assuming a stabilized apartment, right?
They don't say. But
Okay.
if you want to clarify, yes, rent
Okay.
stabilized.
All right. So succession rights have to be asserted relatively promptly after the tenant of record vacates. So the answer to the question would be, when did that tenant leave? If they left 6 months ago, a year ago, maybe even longer, you're okay. If they left 5 years ago, you have a problem. Because I believe now that the courts in Brooklyn, Queens, and Manhattan and the Bronx have all said that if you wait too long, you can't assert succession rights. So it really depends on when they left. I always tell people to do it right away, not to wait any longer. The longest you want to wait in asserting a succession claim is when the new lease is offered, and when the landlord offers a lease to both parties, or to the prime tenant, the sister would then say, the tenant of record has permanently vacated the apartment. Here's where she's living now. We can get you additional documentation to prove that. And I have succession rights because I co-occupied the apartment with my sister from X to Y. And that's usually when it occurs.
Okay. And are any of these rules that we discussed, you know how there's usually exceptions for like a 1 to 3 family house? Does any of that apply here today?
Well, needless to stabilization only applies generally to six or more units, right? Unless you're in what's called a horizontal multiple dwelling, where you're in a series of buildings that are connected and owned by the same landlord, even though there might be, say, 2 or 3 units in each building, combined, they have more than six, right? Um, we covered so much that I can't answer the question. There are certain laws that exempt small buildings, small owner occupied buildings. For example, I think the good cause eviction law has a carve out for small owner occupied buildings. So you really have to look at each law and see if there are carve outs for small landlords, because there are for certain laws, yes.
And what about the duty to mitigate? Does it apply in a situation where someone has a roommate with the lease?
Does the dude, that's not related to the last question, right? So,
No.
all right, does the duty to mitigate, well, meaning you're in an apartment, you have one roommate who's not on the lease?
Right. And they want to break the roommate for whatever reason wants to break you have a lease with your roommate. Um,
Oh,
and
um,
I, as the roommate, just want to leave for whatever reason. Does the prime tenant have a duty to mitigate?
I don't believe so. I think it only applies to landlords, but I'm not sure. I've never had that come up, but on a practical level, you want to mitigate, right? You want to get somebody else in there, but I don't think it apply. I think it only applies to landlords.
Okay. And then maybe I missed it, but like, could you briefly talk about the breaking lease protections when it comes to like a senior who may be entering like a nursing home or treatment?
Well, I mean, the tenant wants to give up the lease because they've been transferred to a nursing home.
Yeah, like maybe, the family realizing they're no longer mentally capable, experiencing dementia or something, and they need to be in like a residential facility essentially at this point.
I'm not sure if there's a specific statute, but it seems to me that that would be a legal basis to terminate a lease if the tenant is no longer physically or mentally able to occupy the apartment.
Okay. Let's see. Any more questions? Just some comments from people like this was incredibly helpful. Thank you so much for this training. Um, yeah.
But you have any other questions? If not, I do want to remind everyone we still have some trainings left for the season. So I think we have a training about overcharges and rent stabilized apartment coming up next week. So I will post the link here along with, and this will be the same page where you can see the PowerPoint along with the presentation. So please feel free to check it out. Maybe overcharge training will be helpful in you making a claim for your breaking the lease. Yeah, definitely. But if we don't have any other questions, um, yeah, um, yeah, thank you so much, Sam. This was
Thank
a
you.
very helpful training. Um, and we all learned something to do, something about breaking leases.
Great. All
Thank
right.
you for attending as well.
All right. Thank you.
Have a good one, everyone.
Have a
Bye.
good one, everyone.